Good evening. I want to tell you a story, a very simple story, which will primarily concern one company. And it will illustrate what happens when the presumption of innocence is cast aside, not just by a court, but more importantly, by a parliament. The company concerned is New Coal Resources. In 2008, Ian McDonald issued a license, a coal exploration license, to a company that was eventually bought by New Coal Resources. The license was eventually taken away by the New South Wales government using special legislation that bypassed or amended, significantly amended the Mining Act. Now, it was based on and was led up to by a report, a spectacular report by the Independent Commission Against Corruption, which ostensibly found the most spectacular episode of corruption since the Rum Corps. It was front page news, spectacular headlines. It ran for weeks. It dominated public discourse in the state for ages. But the thing that is really worrying is that when you look at what the court's made of these accusations, it doesn't quite gel. Now, ICAC made 5 corruption findings in relation to New Coal Resources. 2 of those corruption findings were against former Minister Ian McDonald, who issued the licence, and John Maitland, the then chairman of Doyle's Creek Mining, which received the licence. There were 3 other corruption findings against directors of Doyle's Creek Mining, 2 of whom subsequently joined the board of New Coal Resources. Faced with that, the former Premier, Barry O'Farrell, went into Parliament and told Parliament, look, you've seen what has been unearthed at this inquiry. ICAC recommends these licences be expropriated, be cancelled. You don't have to rely on ICAC though. You've seen what came out at this inquiry. You can make your own assessment. It's worth keeping in mind that Parliament made its own assessment. Parliament decided whether conduct was so significant that a penalty should be imposed, i.e. the cancellation of property, exploration licences. Now, what's wrong with that? Ian McDonald and John Maitland were convicted, went to prison. Subsequently, a 5-judge Court of Appeal in New South Wales unanimously quashed those convictions and ordered a retrial. Okay, that's out of the way. What happened to the 3 directors of Doyle's Creek Mining who were mentioned by Mr. O'Farrell, not by name, but directors? He mentioned directors of Doyle's Creek Mining. One of them, Craig Ransley, was prosecuted. He was in fact, he was prosecuted twice. And twice he was acquitted. Okay, what happened to the other 2? The 2 that joined the board of New Coal Resources. One of them, Andrew Poole, was referred to the Director of Public Prosecutions after the ICAC inquiry. ICAC sent off everything it had learned about this man. And the DPP came back and said, no, sorry, no case here. He was never prosecuted. What about the other fellow? A fellow by the name of Mike Chester. He was declared corrupt. All these people were declared corrupt. ICAC did not even send him off to the DPP. The DPP was not even asked for an opinion on the material that ICAC had assembled on whether this justified a prosecution. So what we've got here, there's problems on a number of levels. What we've got is a parallel system. We've got the court system, which in our system of government has the exclusive responsibility of determining guilt and innocence, of determining conclusively rights and liabilities. But we've also got ICAC declaring people corrupt. And ICAC is a very influential organisation. The Premier clearly was influenced by this. Parliament was clearly influenced by this. So we're in the situation now where New Coal Resources, which was an innocent party, remember this company came along 14 months after the original licence was issued to Doyles Creek Mining. They had nothing to do with the process that Mr. O'Farrell told Parliament was tainted by corruption. This was the issuing of the licence. If you assume that that is correct, that the issuing of the licence is tainted by corruption, remember the convictions of those two men have been quashed. So the law is at odds with the logical basis of the parliamentary decision to impose a penalty on New Coal Resources. New Coal is an innocent party, a third party. It might have made some sense if New Coal was involved in an act of corruption, but there's been no accusation of that. There's been no accusation of wrongdoing against New Coal. The two directors from Doyles Creek Mining who joined the New Coal board, their presumption of innocence is intact. So what happened here? The way I see it, Parliament trampled into territory that is properly best left to the courts. Instead of waiting for a conclusive finding by the courts on whether there had been an act of corruption by McDonald and Maitland, and whether the three directors of Doyles Creek Mining had engaged in any conduct that breached the law, they were persuaded to impose a penalty. This is Parliament imposing a penalty on a third party on a factual basis that is now at odds with the findings of the courts. Now, what sort of penalty are we talking about? This is a company with thousands of individual and family shareholders, institutional shareholders from the United States. This company paid $94 million to buy Doyles Creek Mining, primarily to get its hands on that licence. It then spent another $40 million completing the obligations that were part of the licence agreement with the government. It had to prove up the deposit, engage geologists, drill test bores. So that's well over $100 million that this company had spent. This company where there'd been no accusation of wrongdoing against the company. The accusations of wrongdoing were against third parties. Yet this penalty was imposed on this company because Parliament believed ICAC. The problem, as I see it, is ICAC makes public findings. It has the outward appearance of a court. It is not a court. Its findings are not tested to the same extent that a verdict in a court is tested under the adversarial system. That's the most rigorous system yet developed. It's, in my view, superior to the inquisitorial system, where you must rely on the rigour of the person doing the inquiring. So that's bad enough. But it's not the only case. There's another case, very, very similar, involving another licence that was taken away by legislative fiat. And that involves Cascade Coal, another company that is an innocent third party. It also involved the issuing of a licence by Ian McDonald, this time to a company called Monaro Mining. Cascade got its hands on that particular licence because Monaro could not find $25 million to pay to the government as part of the pledge it made when it pitched for the licence. There was a finding of corruption against the chairman of Cascade, a man by the name of John McGuigan, who happens to be a former global managing partner of Baker & McKenzie. That finding is, in practical terms, was outside ICAC's jurisdiction. As a result of a High Court decision involving one of the previous speakers, Margaret Cunneen, it became very obvious that ICAC had been exceeding its jurisdiction. The Cascade parties had engaged in legal action in the New South Wales Court of Appeal. Margaret Beasley, the then president of the Court of Appeal, had circulated a draft declaration stating that ICAC had no jurisdiction to make the finding it made against John McGuigan and the Cascade parties. So what happened? Before that declaration could be issued and provide a remedy for those people who had suffered a wrong, ICAC had gone down to Macquarie Street and spoken to various people, and the government of Barry O'Farrell's successor, Mike Baird, prepared retrospective legislation which changed ICAC's unlawful conduct, i.e. exceeding its jurisdiction, retrospectively by legislative fiat said, well, we forgive that. That's quite okay. It's now valid. So the effect of that was to deprive victims of unlawful conduct of a remedy that that everybody should be entitled to go to an independent court and seek a remedy for unlawful wrongdoing. But in this case, the influence of ICAC persuaded the government to change the law to protect ICAC's blushes, if you like, and deprive people of a remedy. So what sort of people? Are these criminals? By definition, ICAC is not a court. That means it can't impose penalties. Ostensibly, it can't impose penalties. But it does impose a penalty, a very, very serious penalty. It destroys the reputation and the public standing of innocent people, people who have been convicted of nothing, people who are innocent in the eyes of the law. The remedy for this, I think, is there are two possible remedies. One is an appeal on the merits to ensure that people are given an opportunity, a fair chance to clear their name, correct any errors. That's complex and expensive. A more effective remedy, in my view, would be this. What's the benefit of a public hearing? In most cases, a public hearing follows a private hearing where the same questions are asked. A public hearing, to a degree, would have to come very close to fitting the definition of a show trial. I'd do away with it. The risk to the demolition of private reputation of innocent people, people who have not been convicted of anything, people who might never face a court, people who might never face prosecutors. The prosecutors might not even be asked to have a look at their conduct. So that's number one, do away with those. The next thing I'd do would be do away with public findings. What is the benefit of a public finding other than to create bread and circuses, headlines for newspapers? We've seen a number of times now, and the New Coal example is probably the best, where public findings have been shown to be starkly at odds with the findings of independent courts when independent courts examine the same conduct. Now, it's all very well for ICAC and its defenders to say, oh, well, ICAC has a different standard of proof, and it does. Its standard of proof is very low, and the rigour of its hearings is very low compared to a court. A court deserves respect because of those things, because of the rigour it applies and because of the protection it gives to people who come before courts to ensure that they are not unfairly treated. Those things are not present at ICAC. We've heard this evening how procedural fairness was a relatively late innovation in this commission. So I can't see the benefit of a public finding. So how would it operate without those two things? This would have no bearing on its ability to investigate corruption, to use coercive power if necessary. to get to the bottom of what it suspects is serious and systemic corruption. That would then, if it were to operate as I would hope, would then form the basis for a brief of evidence that would go to the DPP. If the DPP agrees and a prosecution results, terrific. If the DPP disagrees, there's no harm done to innocent people. The presumption of innocence affecting these people, that is a right of these people, would not be infringed. There's two ways of looking at the presumption of innocence. The most limited way of looking at it is that it applies only in a court. And it applies, the logic for that is that courts apply penalties. There's another way of looking at it that it applies generally. And this is had the Parliament of New South Wales recognised that and accepted that, it would not have got itself into the terrible, embarrassing situation it's now in, where the logical basis for the expropriation of the coal exploration licence for new coal resources is illusory. The courts have found that there is no wrongdoing here. Every director who moved from Doyles Creek mining to new coal resources is entitled to a presumption of innocence. Parliament acted in the belief that it could decide, based on conduct exposed at ICAC, it could decide whether that conduct amounted to something that justified Parliament imposing a penalty, not waiting for a court to apply the normal law, but for Parliament to bypass the Mining Act, to bypass due process and impose its own penalty. Now, how does this look from the United States perspective? And remember, there are US institutions that have lost money because of this. This is, forget about the thousands of small shareholders in the Hunter Valley who have been wiped out. Think about the US institutions who don't like the look of this. Now, the United States has a free trade agreement with this country, which guarantees that American assets will not be taken other than through due process of law and followed by prompt and adequate compensation. Now, even ICAC, when it recommended the removal of these coal exploration licenses, said you really should compensate innocent parties. Now, Mr. O'Farrell, when he took his expropriation legislation to Parliament for his own reasons, decided that the government should simply take this property and not compensate. Now, that's bad enough, but to take property from innocent people, people who have been found not to have engaged in breaking any law of New South Wales, looks pretty dicey from a foreign perspective. So the message here is that it's very unwise. It might be within Parliament's power to do what it's done and jump the gun, get in before the courts, make its own findings about what conduct, what penalty it should impose as a result of particular conduct, and then impose a penalty. It might have the power, but it's unwise to do that. Parliament should learn from this and step back a little bit and recognise that we have a perfectly good justice system with rules that have developed over the centuries that are designed to ensure fair treatment. ICAC has been around since 1988, and its procedures have been radically changed in the last few years as a result of problems coming to light. Now, the new coal resources issue and the Cascade coal resources issue is the latest in a string of decisions which, in my view, necessitate another tranche of reform. Public hearings are they can too easily descend into prurience. We've only got to look back a little bit at what happened to the Premier of this state, where her private life was exposed to public ridicule at a public hearing. For what good reason? Because it has also come to light that this commission had also asked Ms. Berejiklian about those matters at a private hearing. And then it repeated that and went over the same ground for the benefit of the media. Again, this comes very close to being what I consider to be a show trial. If there's to be a place, a continuing place for a commission like this, for an anti-corruption watchdog, it needs to be brought more into line with the orthodox mainstream justice system. The idea of setting up ICAC, I think, was a good idea at the time. I think in retrospect and after a series of cases, it's become pretty obvious that there's another need, there's a need for a continuing look at this organisation. One thing to keep in mind is every state now has one of these organisations. New South Wales was the first, and not one of those interstate commissions operates in the same manner as the New South Wales Commission. South Australia, for example, has no public hearings, no public findings. They still manage to root out corruption, but it's an orthodox part of the South Australian justice system. South Australia hasn't collapsed into a heap of wrongdoing, but the cost of having an organisation like ICAC that runs in parallel to a legitimate justice system, I think is far too great. Now that's the last of our presentations for this evening, but we are going to have some questions, and I'll leave that to Sally.